Welcome back to Insurance World TV, our insurance education channel. In today's video, we will be discussing an important aspect of public liability insurance policies, the cross-liability clause. Understanding this clause is crucial for businesses and individuals seeking comprehensive coverage and protection in case of accidents, damages, or injuries caused by their actions or negligence. So, let's dive right in. What is a cross-liability clause under public liability policy? A cross-liability clause is a provision typically found in public liability insurance policies. It is designed to provide coverage in situations where multiple parties are insured under the same policy and one party's actions or negligence cause harm or damage to another insured party. In a standard public liability policy, the coverage is usually provided to the insured entity or organization named in the policy. However, in some cases, multiple parties may be included as insured entities under the same policy, such as in the case of a group of companies or individuals. The cross-liability clause ensures that each insured party is treated as a separate entity for the purposes of insurance coverage. It means that if one insured party becomes liable for a claim due to its actions or negligence, the coverage is not affected for the other insured parties. Each party is protected against claims made by other insured parties, allowing them to seek indemnification from the insurance policy. For example, let's say a public liability policy covers two companies, Company A and Company B. If an incident occurs where Company A's actions cause damage to Company B's property, the cross-liability clause ensures that Company B can file a claim against the policy to seek compensation for the damage caused by Company A. The policy will cover Company B's claim independently of the liability of Company A. The cross-liability clause helps prevent disputes among insured parties and allows for a fair and separate treatment of each insured entity under the policy. It ensures that the coverage is effective and applies to all insured parties as if they had separate policies, even though they are covered under a single policy. Importance of having cross-liability clause under a public liability policy. Having a cross-liability clause in a public liability policy is of significant importance for several reasons. 1. Protection for insured parties. The cross-liability clause ensures that each insured party is adequately protected against claims arising from the actions or negligence of other insured parties. If one party's actions cause harm or damage to another insured party, the clause allows the injured party to seek compensation without affecting the coverage of the other parties. It provides a sense of security and peace of mind for all insured entities. 2. Minimizing disputes and litigation. In the absence of a cross-liability clause, disputes can arise between insured parties regarding who is responsible for a claim and whether their actions are covered by the policy. By including this clause, potential conflicts and litigation are minimized. Each party can file a claim independently, reducing the chances of disputes and streamlining the claims process. 3. Comprehensive coverage. Public liability policies are meant to provide broad coverage for bodily injury, property damage, and other liabilities. The cross-liability clause ensures that each insured party has access to the full coverage limit of the policy, irrespective of the actions of other insured parties. It ensures that all parties are adequately protected and can seek compensation for their own losses. 4. Flexibility and collaboration. In situations where multiple parties are covered under the same public liability policy, the cross-liability clause allows for flexibility and collaboration among the insured entities. It enables businesses or individuals to work together without worrying about potential liability issues arising from the actions of other parties. This encourages cooperation and joint ventures while maintaining adequate insurance protection. 5. Risk management. The cross-liability clause plays a crucial role in risk management. It allows insured parties to focus on their own operations and activities without constantly worrying about the actions or negligence of other parties covered under the same policy. Each party can manage its risks independently, knowing that they are individually protected by the insurance coverage. 3. Fairness and equity. Including a cross-liability clause promotes fairness and equity among insured parties. It ensures that the policy functions as if each insured party had a separate policy, with coverage specific to their individual circumstances. This eliminates any potential inequities or biases that could arise if the liability was shared among all parties without distinction. Overall, the cross-liability clause is essential in a public liability policy as it provides protection, minimizes disputes, offers comprehensive coverage, encourages collaboration, facilitates risk management, and ensures fairness among insured parties. Its inclusion enhances the effectiveness and reliability of the policy for all parties involved. Examples and scenarios where cross-liability clause may apply. Here are a few examples and scenarios where the cross-liability clause in a public liability insurance policy may come into play. 1. Construction project. Suppose a public liability policy covers multiple contractors working on a construction project. If one contractor's negligence leads to property damage or bodily injury to another contractor or third party, the cross-liability clause ensures that the injured party can file a claim against the policy to seek compensation independently. 2. Manufacturing facility. In a public liability policy covering a manufacturing facility with multiple entities involved, such as suppliers, distributors, and subcontractors, the cross-liability clause becomes relevant. If one entity's defective product causes harm or damage to another entity or third party, the clause allows the injured party to seek coverage and indemnification under the policy, regardless of the liability of the entity responsible for the defect. 3. Event organizers. Consider a public liability policy covering event organizers, including vendors, performers, and contractors. If an incident occurs during the event where one party's actions cause harm or injury to another party, the cross-liability clause ensures that each party can seek compensation and coverage from the insurance policy individually. 4. Professional services. In a scenario involving a professional services firm, such as an accounting or consulting firm, where multiple professionals are covered under a public liability policy, the cross-liability clause is crucial. If one professional's negligent advice leads to financial losses for another professional or client, the clause allows the affected party to file a claim against the policy independently. 5. Rental properties. When a public liability policy covers multiple rental properties owned by the same entity or individual, the cross-liability clause ensures that if one property causes damage or injury to another property or tenant, each party can seek coverage and compensation individually, without affecting the liability of the property responsible for the damage. These examples illustrate situations where the cross-liability clause is essential for ensuring fair and separate coverage for each insured party. It allows for independent claims handling and protects parties from being held responsible for the actions or negligence of others covered under the same policy. Key considerations and limitations of cross-liability clause in public liability policy. When reviewing and interpreting the cross-liability clause in a public liability policy, there are several key considerations and limitations to keep in mind. 1. Coverage limitations. It's important to understand the specific scope and limitations of the cross-liability clause within the policy. Different policies may have varying terms and conditions regarding the extent of coverage provided to each insured party. Carefully review the policy language to ensure that the clause adequately addresses the needs and requirements of all insured parties. 2. Policy exclusions. Public liability policies often include exclusions that specify certain situations or types of claims that are not covered. While the cross-liability clause extends coverage to each insured party, these exclusions still apply. It's crucial to review the policy exclusions to understand any potential gaps in coverage that may affect the application of the cross-liability clause. 3. Independent liability. The cross-liability clause treats each insured party as separate entities for the purposes of liability and coverage. It's important to understand that the clause does not eliminate or transfer liability between parties. Each party remains individually responsible for their actions or negligence, and the clause ensures that coverage is provided independently without affecting the liability of other insured parties. 4. Contribution and subrogation. Depending on the jurisdiction and policy language, there may be provisions related to contribution and subrogation. Contribution refers to the sharing of liability among multiple responsible parties, and subrogation involves the insurance company seeking recovery from a responsible third party after paying a claim. These provisions may interact with the cross-liability clause, and their implications should be understood within the policy context. 5. Policy coordination. In situations where multiple insurance policies are involved, coordination and interaction between policies may be necessary. It's important to consider how the cross-liability clause in one policy aligns or interacts with other relevant insurance policies to ensure comprehensive coverage and avoid potential gaps or overlaps. 6. Policy specifics and legal advice. Public liability policies can vary in their language, terms, and conditions. To fully understand the implications of the cross-liability clause, it may be beneficial to consult with an insurance professional or seek legal advice. They can provide guidance on interpreting the specific language of the policy and its impact on each insured party. Understanding these key considerations and limitations will help insured parties make informed decisions when selecting or reviewing a public liability policy with a cross-liability clause. It ensures that the clause aligns with their needs and provides the desired level of protection for all parties involved. Expert insights and recommendation. Expert insights and recommendations regarding the cross-liability clause in a public liability policy can provide valuable guidance for businesses and individuals. Here are some expert insights and recommendations. 1. Seek professional advice. Consulting with an experienced insurance professional or broker can help navigate the complexities of the cross-liability clause. They can provide personalized advice based on your specific needs and ensure that the policy adequately protects all parties involved. Their expertise can help you understand the implications of the clause and make informed decisions. 2. Review policy language. Thoroughly review the policy language related to the cross-liability clause. Pay close attention to the wording, definitions, and any limitations or exclusions. It's essential to have a clear understanding of how the clause operates within the policy and how it may impact coverage for each insured party. 3. Consider specific risks. Assess the unique risks and exposures of your business or situation. Evaluate how the cross-liability clause addresses those risks and whether the coverage provided is sufficient. Expert advice can help identify any potential gaps and recommend additional coverage options or endorsements to enhance protection. 4. Contractual agreements. If you enter into contractual agreements with other parties, ensure that the cross-liability clause aligns with the requirements outlined in those agreements. Contracts may specify the need for separate and independent coverage for each party involved. It's important to review and align your insurance policy accordingly to meet those contractual obligations. 5. Regular policy reviews. Public liability policies should be reviewed periodically, especially when there are changes in the business structure, partnerships, or contractual relationships. Revisit the cross-liability clause during these reviews to ensure it remains suitable for your evolving needs. Keep in mind that policy language and endorsements can change over time, so staying informed is crucial. 6. Coordinate with other policies. If there are other relevant insurance policies in place, such as professional liability or property insurance, coordinate with them to ensure comprehensive coverage. The cross-liability clause should be harmonized with other policies to avoid gaps or overlaps in coverage. 7. Document collaboration agreements. In situations where multiple parties are covered under the same policy, it's advisable to have collaboration agreements or contracts in place. These agreements can clearly define the expectations, responsibilities, and liabilities of each party. This can help avoid misunderstandings and facilitates smooth claims handling processes. Remember, expert insights and recommendations can provide valuable guidance, but it's essential to tailor them to your specific circumstances and consult with professionals who have a deep understanding of insurance and liability issues. By doing so, you can ensure that the cross-liability clause effectively protects all parties involved in a public liability insurance policy. Conclusions. In conclusion, the cross-liability clause is a crucial provision in a public liability insurance policy. It ensures that each insured party is treated as a separate entity with independent coverage, regardless of the actions or negligence of other insured parties. This clause offers several benefits, including protection for insured parties. The cross-liability clause provides individual protection to each insured party, allowing them to seek compensation independently if they are held liable for damages or injuries caused to others. Minimize disputes and litigation. By treating each party separately, the clause helps prevent conflicts and disputes among insured parties, reducing the likelihood of litigation and facilitating a smoother claims process. Comprehensive coverage. The clause ensures that all insured parties have access to the full coverage limit of the policy, enabling them to receive the necessary financial support in the event of a claim. Flexibility and collaboration. With the cross-liability clause in place, insured parties can collaborate and engage in joint ventures with confidence, knowing that their coverage remains intact regardless of the actions of others. Effective risk management. The clause allows insured parties to focus on their own operations while managing their individual risks, without constant concerns about potential liability arising from other insured parties. However, it's important to consider key considerations and limitations associated with the cross-liability clause. Understanding the specific terms and conditions of the policy, reviewing policy language, and seeking professional advice are recommended to ensure proper coverage alignment and address any potential gaps or exclusions. Regular policy reviews, coordination with other insurance policies, and clear documentation of collaboration agreements further enhance the effectiveness of the cross-liability clause. By understanding and leveraging the benefits of the cross-liability clause, businesses and individuals can have peace of mind, knowing they have comprehensive protection and support in the event of a liability claim. That's all for today's video. If you found this information helpful, please give it a thumbs up and subscribe to our channel for more educational content on insurance-related topics. Thank you for watching, and we'll see you in the next video.